Iowa gives landlords broad freedom to set and raise rent within a well-structured statutory framework that benefits from the state's adoption of the Uniform Residential Landlord and Tenant Law. The governing statute is Iowa Code Chapter 562A, and while it doesn't restrict the amount a landlord can charge, it establishes clear procedural requirements and tenant protections that landlords must follow. Iowa does not have rent control or rent stabilization of any kind. There is no state statute that caps rent increases, limits the frequency of increases, or requires landlords to obtain government approval before raising rent. Iowa's political and regulatory environment favors property rights and market-based pricing, and rent control has not gained meaningful legislative traction. Iowa has enacted a preemption statute that prevents local governments from enacting rent control. Under Section 364.3, Iowa municipalities are prohibited from adopting ordinances that would control the rent charged for residential property. This means Des Moines, Cedar Rapids, Iowa City, Davenport, and every other Iowa community are legally barred from implementing rent caps. The preemption ensures a uniform statewide framework and gives Iowa landlords certainty regardless of where their property is located. For month-to-month tenancies, the landlord must provide advance written notice before a rent increase takes effect. Iowa requires at least 30 days written notice before the next periodic rental date for changes to the terms of a monthly tenancy. So if rent is due on the 1st, and you want the increase to take effect on May 1st, you need to deliver the notice by April 1st at the latest. The notice should be in writing and should clearly state the current rent, the new rent amount, and the effective date. Iowa doesn't prescribe a specific statutory form for rent increase notices, but a clear written notice delivered by a documented method is always recommended. Acceptable delivery methods include personal delivery, leaving a copy at the tenant's usual place of residence, or sending by mail. For fixed-term leases, the rent is locked in for the duration of the lease term unless the lease includes a provision allowing midterm increases. Common midterm adjustment provisions include escalation clauses, provisions tied to property tax changes, and CPI-based formulas. Without such a provision, the landlord must wait until the lease expires to negotiate a new rent as part of a renewal or new lease. When a fixed-term lease approaches expiration, the landlord should communicate the proposed new rent well in advance. If the tenant agrees, a new lease is executed at the new rate. If the tenant doesn't agree, the lease expires at its natural end. If the tenant stays and the landlord accepts rent, the tenancy converts to a month-to-month arrangement, subject to the 30-day notice requirement. For week-to-week tenancies, the notice period for rent changes is 10 days, which is slightly longer than the 7-day standard most states use for weekly tenancies and is specific to Iowa's statute. Now let's cover the restrictions that apply even without rent control, and Iowa has some noteworthy protections. Rent increases cannot be retaliatory. Iowa has one of the strongest anti-retaliation statutes in the Midwest, under Section 562A.36. Landlords cannot raise rent in retaliation for a tenant exercising any right under the Uniform Residential Landlord and Tenant Law. Protected activities include making a good faith complaint about habitability to a government agency, reporting a code violation, complaining to the landlord about conditions that violate the rental agreement or applicable codes, exercising any right under Chapter 562A, and organizing or joining a tenants organization. Iowa's anti-retaliation provision creates a rebuttable presumption of retaliation if the landlord takes adverse action within 1 year of the tenant's protected activity. 1 year is one of the longest presumption periods in the entire country, significantly longer than the 6-month standard used by many states. This means that any rent increase delivered within 12 months of a tenant's complaint carries an automatic inference of retaliatory motive. The landlord must then demonstrate that the increase was motivated by legitimate business reasons entirely unrelated to the tenant's complaint. Given this extended presumption period, Iowa landlords need to be exceptionally careful about the timing of rent increases relative to tenant complaints. If a tenant filed a habitability complaint 8 months ago and you're now raising rent, the 1-year presumption still applies. Your documentation must clearly demonstrate that the increase was planned independently, is consistent with increases applied to other comparable units, and is justified by market conditions or operating cost changes. The consequences of a retaliatory rent increase in Iowa include liability for actual damages and up to 2 months' rent, whichever is greater, plus attorney's fees. These are significant penalties that make retaliatory rent increases a costly mistake. Rent increases also cannot be discriminatory. Under the Federal Fair Housing Act and the Iowa Civil Rights Act, found in Iowa Code Chapter 216, landlords cannot raise rent based on a tenant's race, color, religion, national origin, sex, sexual orientation, gender identity, disability, or familial status. Iowa's anti-discrimination protections are broader than the Federal Fair Housing Act. The inclusion of sexual orientation and gender identity provides additional categories of protection. The Iowa Civil Rights Commission investigates fair housing complaints and can take enforcement action, including ordering damages, injunctive relief, and civil penalties. A discriminatory rent increase, one that targets tenants based on any protected characteristic, can result in significant liability. Iowa also has general consumer protection principles under the Iowa Consumer Fraud Act that could apply to egregious landlord conduct involving rent increases. If a landlord uses deception or fraud in connection with a rent increase, fabricating cost increases, misrepresenting the reason for the increase, or engaging in other unfair practices, the tenant might have a claim under consumer protection law. From a practical standpoint, Iowa's rental market is diverse, with several distinct metropolitan areas and a range of conditions across the state. Des Moines, the state capital and largest city, has the most active rental market in Iowa. The city's economy is driven by insurance and financial services. Des Moines is one of the largest insurance industry centers in the world, along with healthcare, technology, and a growing startup ecosystem. The Des Moines metro area, including West Des Moines, Ankeny, Urbandale, and Waukee, has experienced steady population growth, and rents have increased consistently. Landlords in the Des Moines area generally have reliable pricing power, and the market supports regular annual increases. The Des Moines Metro offers a range of price points. Downtown and the East Village have attracted young professionals and command higher rents. West Des Moines and Ankeny attract families and offer newer construction at moderate to higher price points. The suburbs continue to grow, expanding the metro's rental footprint. Cedar Rapids, Iowa's second-largest city, has a rental market driven by manufacturing, including Collins Aerospace and Quaker Oats, healthcare, and regional commerce. The city experienced significant flooding in 2008 that damaged or destroyed thousands of housing units, and the rebuilding process reshaped the housing stock. Rents in Cedar Rapids have increased moderately, and the market is stable. Iowa City, home to the University of Iowa, has one of the tightest rental markets in the state. The university drives strong and consistent demand for both student and non-student housing. The UI hospitals and clinics, one of the premier academic medical centers in the Midwest, add healthcare employment to the demand equation. Rents near campus are high relative to the city's size, and the student housing market is intensely competitive. Rent adjustments in the student market typically occur at the beginning of each academic year. Iowa City's rental market has a unique characteristic. The city has a well-organized and active tenant advocacy community, driven in part by the university's student population and the city's progressive political culture. While Iowa's preemption statute prevents local rent control, Iowa City tenants are generally well-informed about their rights and are more likely to challenge increases they perceive as excessive or retaliatory. Ames, home to Iowa State University, has a similar student-driven dynamic. The university's large enrollment creates strong demand for housing near campus, and rent adjustments follow the academic calendar. The broader Ames market benefits from the university's economic impact and a growing technology sector. Davenport and the Quad Cities, which straddle the Iowa-Illinois border, have a rental market influenced by manufacturing, healthcare, and regional commerce. The market is moderate and stable, with pricing power that varies by neighborhood and proximity to employment centers. Waterloo and Cedar Falls have a rental market influenced by the University of Northern Iowa, manufacturing, including John Deere, and healthcare. Student housing near UNI follows the academic calendar, while the broader market is moderate. Dubuque has experienced notable economic revitalization, with investments in technology, tourism, and education driving growth. The rental market has tightened in recent years, and landlords have seen improved pricing power. Sioux City in western Iowa has a rental market influenced by meatpacking and food processing, healthcare, and regional commerce. The immigrant and refugee workforce employed in the food processing industry represents a significant portion of the rental market. Rents are affordable and pricing power is moderate. Rural Iowa has the softest rental markets. Many farming communities have experienced population decline as agriculture has become more mechanized and younger residents have moved to urban areas. Landlords in these communities have limited pricing power and need to be conservative about increases. However, some rural Iowa communities near ethanol plants, wind energy facilities, or other new economic development may see localized demand that supports modest increases. One best practice for Iowa landlords, given the state's one-year anti-retaliation presumption, establish a consistent and documented annual schedule for rent increases across all your properties. If every tenant receives an increase at the same predictable time, such as at lease renewal or on a fixed calendar date, the pattern demonstrates that increases are routine business decisions. Keep detailed records of market comparables, operating cost changes, and property improvements for every increase. In Iowa, where the retaliation presumption extends for a full 12 months, your documentation is your primary defense. Another best practice, for landlords in university towns like Iowa City and Ames, understand the competitive landscape for student housing. Purpose-built student apartments with modern amenities, proximity to campus, and all-inclusive pricing have become increasingly competitive. If your properties compete in the student market, your rent increases need to reflect what students are willing and able to pay relative to these alternatives. Overpricing relative to the student competition can lead to vacancies that are particularly costly in a market with a fixed academic calendar. If you don't fill a unit by the start of the semester, it may sit empty for the entire term. For landlords who own properties near Camp Dodge or other military facilities, understanding BAH rates and military housing dynamics helps you price competitively for the military demographic. Iowa's military presence is smaller than in some states, but landlords near military facilities benefit from understanding the housing allowance structure. Iowa's agricultural economy creates seasonal and cyclical dynamics in rural rental markets. During strong commodity price cycles, particularly corn and soybeans, farm communities may see slightly increased demand. During weak cycles, demand softens. Landlords in agricultural communities should be aware of these dynamics without overreacting to short-term price swings. Iowa also has specific requirements for manufactured home community lot rents under Chapter 562B, the Manufactured Home Communities Act. Landlords who own or manage manufactured home parks must follow specific notice and procedural requirements for lot rent increases that differ from standard residential tenancies. These requirements include specific notice periods, content requirements, and in some cases, limitations on the amount of the increase. For Iowa landlords who participate in the Housing Choice Voucher Program, rent increases must be approved by the local housing authority. The authority evaluates whether the proposed rent is reasonable by comparing it to comparable unassisted units. Submit increase requests well in advance of the desired effective date. Iowa requires landlords to return the security deposit within 30 days of the tenant vacating. If the landlord fails to return the deposit within 30 days, they may be liable for up to twice the amount wrongfully withheld. Iowa limits the security deposit to 2 months' rent. While these rules don't directly regulate rent increases, landlords should understand that increasing rent doesn't automatically entitle them to collect additional deposit from an existing tenant without a new agreement. For the complete guide to Iowa rent increase laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our landlord-tenant law series.